Benjamin Franklin said it best. In this world, nothing is certain except death and taxes. But if we plan right, we can at least control one of those. Important information coming up on this next episode of The Secrets of the 1%. Welcome to The Secrets of the 1%. I am Amelia Thomas, the managing partner of Empire Capital Ventures. We help first-generation millionaires generate 9 figures in wealth through advanced tax planning and wealth management. I know estate planning is a tough topic, but it's an absolutely critical portion of any financial plan. We've all heard the horror stories about celebrities who did not make plans for their estates after their deaths. Failing to plan is a plan and not a good one. When you die without an estate plan, you are allowing a judge to make a decision on your behalf once you pass. Just a few simple steps can alleviate all of the drama. So who needs estate planning? It is a common belief that estate planning is only for the uber wealthy. Unfortunately, that is a myth that can leave many families in ruins when faced with unexpected life decisions. Everyone needs some form of estate planning. If you are a small business owner, you need estate planning. If you have a blended family, you need estate planning. If you have assets, whether you're wealthy or not, that you want to make sure go to certain individuals, you need estate planning. The goals behind estate planning are, number 1, to keep the wealth and any assets that have been passed down in the family, like grandmother's house. Number 2, to use that wealth during your lifetime while it still continues to grow. Number 3, to pass along as much as possible to your heirs with the least amount of taxation. While I understand everyone may not have significant wealth yet to pass on, most people will find that even at the basic level, they will need some form of estate planning. So let's discuss the basics. We have wills, power of attorneys, and advanced medical directives. A will is a legal document where one's final wishes are expressed in terms of the distribution of assets. This document is still subject to the probate process. However, a judge will take into consideration your wishes on how you would like your assets passed on, as well as who should be appointed the legal guardian for minor children. Without this, you're allowing a judge to make really critical decisions, like who will care for those minor children after you are gone. In addition, probate fees can be extremely expensive. So what are a few ways to pass assets to loved ones without the use of a will or a trust? Consider adding a payable on death or a transfer on death title to any of your bank accounts. This is essentially adding a beneficiary to those accounts, which will avoid the probate process. Consider adding a joint account holder. If you choose this option, that person will have all of the same rights as you on the account. So be certain that it is someone that you trust implicitly. If you do not want that person to have complete access, adding a POD or TOD will be a better option. Next, power of attorney. A power of attorney is a legal document that gives someone else the authority to act on your behalf. There are multiple power of attorney documents: the general, durable, and springing powers of attorney. A general power of attorney is a legal document that gives someone else the authority to act on your behalf until the point of incapacitation or death. A springing power of attorney is a legal document that springs into action upon incapacitation. This also means that typically the document will not become valid until a doctor certifies that the appointee is incapacitated. If you do not want a delay and the attorney being able to handle any business on your behalf, this type of legal document may not be best suited for your needs. Third on our list of basics is an advanced medical directive. Also known as healthcare directives, these legal documents allow you to specify in advance your wishes for end-of-life healthcare. This document allows you to appoint a healthcare proxy who would make medical decisions on your behalf and to make certain that your wishes are honored. Decisions like the use of a ventilator, CPR, feeding tubes, and IVs, as well as instructions for hospice care. This is very important for people who do not want extraordinary measures to save their lives or to be kept alive in a vegetative state. For example, in my own healthcare directive, I made the decision that I don't want to remain on a ventilator after 2 doctors have certified that I will not recover. However, my mother doesn't believe in pulling the plug. So if I don't have that document in place, my wishes would not be followed, and my mother may choose to leave me on a ventilator permanently. You should also know that if you do not plan accordingly and set up an estate plan, your assets will be subjected to the probate process. The objective of the probate process is to, number 1, to collect taxes, number 2, to pay off creditors, and number 3, to distribute the remaining assets of the heirs according to the provision of the will or based on the judge's orders. The entire process is overseen by a probate judge who will appoint an executor to probate the estate, which is typically a family member. This person will be responsible for gathering all of the assets. Then the executor will provide an inventory to the judge. Probate processes are public record, and therefore once the creditors are notified, a notice is typically made public in a newspaper and online. The executor may be responsible for holding an estate sale to liquidate assets to pay off all valid debts, expenses, and taxes prior to the heirs receiving any of the remaining assets. Here are the advantages of probate. Number 1, it's seemingly fair and orderly. The probate judge's role is to serve as a disinterested party to settle any disputes. Number 2, it's public record. As a result, creditors and government agencies can be certain that they receive what is legally owed by the settling of debts and the payment of taxes. Heirs can be certain that the deceased person's creditors cannot attempt to reclaim title to an asset. There are also some disadvantages to probate. Number 1, it can be a very costly process. To probate an estate, there are a number of expenses, including but not limited to fees paid to attorneys, auctioneers, accountants, as well as appraisers, as well as the personal representative. Number 2 is public. When we hear about the families of high-profile celebrities who have passed and they are fighting over the assets, it is genuinely because they failed to create a solid plan before they pass. Otherwise, you would never hear about any settlement amounts, debts, or having to deal with long-lost relatives. Number 3, it can also be a very lengthy process. It can take several months to years to probate an estate based on the complexity of the assets. The longer it takes to settle, the more expenses the estate will incur. There are generally 3 types of properties that are included in the estate and will be subject to the probate process without estate planning. Number 1 is real property. This includes real estate, land, your primary residence, vacation homes, timeshare ownership. Number 2, intangible property. Intangible property is property that you legally own but cannot physically touch, such as patents, copyrights, inventions, or other intellectual property. Number 3, tangible property. Tangible property are things that you can touch, such as collectibles, coins, cars, antiques, furniture, etc. There is much more to cover regarding estate planning, but you need to be an insider to find out. Head over to theweeklywealthreport.com for more information. Thanks for joining us. I'm Amelia Thomas, and see you next time for the next episode of The Secrets of the 1%.
The Convo, your home for conversations on Black entrepreneurship and wealth, available on your favorite platforms.